pure, led by the flag for which we stand. Blue for the mind that seeks the good and true, red for our promise in the day, white for the glory of a heart that's pure, bright with an ever-shining flame. Alma Mater, we hail, Lord, give the us and great success. The truth and love will conquer all, for God our land and SFS. Alma Mater, we hail, God give the us and great success. The truth and love will conquer all, for God our land and SFS. Truth and love, let us unite to our glorious college name. High on the hill, a beacon light sheet, leading our children on to faith. March on to glory is a message world, spread truth and love with far and wide. Loyal to the hands to raise of guidance, teacher and pupil side by side. Alma Mater, we hail, God give the us and great success. The truth and love will conquer all, for God our land and SFS. Alma Mater, we hail, God give the us and great success. The truth and love will conquer all, for God our land and SFS.
A very good morning to one and all present here. Thank you for joining for us for today's webinar. My name is Ms. Kavita Gavhade and I am working as an assistant professor in Computer Science Department, SFS College, Nagpur. It's a wonderful day and I'm feeling extremely honored and privileged to extend my warm welcome to all the guests and participants present here. I heartily welcome our chief guest, Dr. Lionel D'Souza, our resource person for the day, Dr. Emima Jeronsia, and our beloved principal, Dr. K.T. Thomas, sir. I welcome all my colleagues, friends, and students. Now, I would like to share some highlighting facts about our college. St. Francis de Sales College is a Catholic Christian minority institution managed by the Catholic Archdiocese of Nagpur. The college is affiliated to Rashtrasant Tukaroji Maharaj Nagpur University, Nagpur. St. Francis de Sales College was founded in 1956 by our venerable founder, chairman, late Archbishop Eugene D'Souza, a visionary whose goal was to promote excellence, higher education, and foster human values. St. Francis de Sales College is one of the oldest colleges in the Vidarbha region of Maharashtra. The college is run by SFS College Society, which is registered society under the Societies Registration Act 1860. Though a religious minority institution, the college welcomes employees and students belonging to different castes and religion, and students from diverse economic strata. A well-equipped digitized library, an audiovisual conference room, a state-of-art seminar hall with modern facilities, labs for research to facilitate the teaching and learning process. The college offers different courses in science and arts. The college has been assessed and re-accredited A grade with CGPA of 3.23 by the National Assessment and Accreditation Council, Bangalore. Now, I would like to share some information about today's workshop. Today's workshop about intellectual property rights, that is IPR, is organized by our college in order to make all of us aware about its importance. Intellectual property (IP) contributes enormously to our national and state economics. Dozens of industries across our economy rely on the adequate enforcement of their patents, trademarks, and copyrights. I request all the participants to post their queries and questions in the respective chat boxes in Google Meet as well as on YouTube. Now, proceeding further, I would like to request Dr. Dilip Sadhankar sir to introduce and welcome our chief guest, Dr. Lionel D'Souza, and share a glimpse of his academic journey. Over to you, Dilip sir.
Thank you, Kavita ma'am. Am I audible to you?
Yes, sir.
Good morning, everyone. I, Dr. Dilip Sadhankar, Assistant Professor, Department of Computer Science, on behalf of St. Francis de Sales College, welcome our chief guest, Dr. Lionel D'Souza. We are grateful to him for accepting our invitation and becoming a chief guest of today's event. I am profusely elated to take an opportunity to introduce our chief guest of the day. Our chief guest doesn't require an introduction as he is well recognized figure in SFS arena. Dr. Leonel D'Souza is a well-published and award-winning professor, philanthropist, and international education, healthcare, and pharmaceutical marketing professional. He is engaged in global higher education development and is actively involved in advancing the educational need of aspiring and deserving population worldwide. His current projects are in the USA, India, Middle East, and Africa. As a professor, he graduates many doctoral graduates and is the recipient of several awards and nominations for excellence in doctoral and master's advisement in the discipline of management, business, healthcare, and marketing in leading US institutions. Dr. D'Souza is the Executive Director of University Go Global, an organization that creates worlds of opportunities for students and universities toward one goal of expanding the frontiers and boundaries of knowledge and innovation globally. Sir, we are truly delighted with your presence. I request you to please take over the session.
Thank you very much, Dr. Dilip Sadankar and Ms. Kavita Gawade. Thank you very much for this distinct honor and privilege to be the chief guest and to present here. Well, intellectual property rights, I'm going to cover some of the aspects of those rights, not only as they pertain to India, but across the globe. We can to get an idea of what's happening, what are the infringements, what are the violations, what are the opportunities, and what aspects of protection one must put in place to ensure that your hard-earned intellectual property, your copyrights, patents are protected. So as the name itself implies, intellectual means something that is prepared by one's intellect, by one's acuity, one's brains. And generally, those are intangibles. They are intangibles till they come to the world and then they surface as tangibles. So what that means is that one has an idea, one has a lyric in mind or some poetic kind of inspiration, but so that's an intangible. And now when it makes its presence in the world as a recording, a product, and some other kind of manifestation, then it takes on the form of a tangible. When it takes on the form of a tangible, then it is out in the world, and then there are possible areas of infringement. So in order to protect the wealth, the property of the person who has invented or the person who has come up with this product, service, or whatever it is, including some artistic forms like poetry, recordings, songs, and so on. The governments of India as well as around the world have different forms of legislation to ensure that those intellectual properties are protected. And that, in brief, is what intellectual property means. Now, under that, there are different forms of intellectual property, and there are different acts of law to guarantee, depending on the nature of the intellectual property, and therefore to protect those rights. So there would be the Copyright Act, which was framed in 1957, the Patents Act, which was in 1970, and then you have the Trademarks Act, which was 1999, and so on. The Geographical Indication of Goods, which was in 1999, as the electronic media gained in usage and in scope. Then there's also the Semiconductors Integrated Circuit Layout Design Act of 2000. So as you can see, it's more recent as things have evolved. And then in terms of biodiversity, on biological diversity, that's in 2002 when that act came into being. Now, all these acts are to guarantee, to protect, and there are different treaties, different conventions across the world that most, I would say, countries, advanced countries, emerging markets are signatories to those conventions and so on, and some utterly flout and disregard them. So it all depends. In India, we have a robust system where there is due protection of intellectual property, but that doesn't mean to say there are not any violations, there are not any infringements. So therefore, it is incumbent upon the artist, the software developer, anybody that prepares artistic works or comes up with some intellectual manifestation of work in a concrete form, from the intangible to the tangible. It behooves them to really get all the paperwork, do the registration in the appropriate forms and forum, get the registration so that you have some form of protection. Now, in terms of all these different forms of protection and covered under the different acts, they are all time bound. For example, a patent might have a time span of 20 years. And you can see that with pharmaceutical drugs. When drugs come into the market, if they are blockbusters, let's say what was known as Tagamet or any other such drugs, they generally have a lifespan, an initial lifespan of 20 years protection by the original manufacturer, whether it is a GlaxoSmithKline, whether it is AstraZeneca, Merck, whoever is the original inventor. So that's another term, invention. Once patent runs out after the expiration of 20 years or so, then other players come into the marketplace, the generic drugs, and the generic drugs would be the exact bioequivalent of the original. However, much cheaper and more accessible by everybody. So there would be no difference in the bioequivalence, the therapeutic properties. The only thing that would be different is that it would be from a generic company And those companies, as we know, India has the most number of pharmaceutical companies in the world, statistic that we should be proud of. So that's the lifespan of a patent. Now, with copyrights, copyrights would be artistic works, writings, and so on. As you can well imagine, that lifespan is considerably longer. That lifespan is about 60 years. So what that means, if you have a song by Lata or Kishore Kumar, they have exclusive rights for about 60 years. Of course, in those exclusive rights, maybe the composer is also in that mix. Now, citing some recent examples where in copyrights there have been infringements. Let's take a very recent example of one of the greatest rock songs of all time, called Stairway to Heaven. Suddenly, that song has been out since the 1970s, thereabouts, and suddenly in 2010, somebody or thereabouts, somebody claimed that it was stolen from somebody else. So it went to court, there was litigation, and any of these kind of lawsuits, as you will well imagine, they would involve millions of dollars if one side, the complainant, was able to prove that that artistic work was stolen from them. So it went to court, it went to trial, it was dismissed once, and then it was dismissed the first time, saying that the sequence or the chord progression was based on very common kind of sequence in music. So one couldn't claim that anybody held the exclusive rights, the proprietary rights over that progression. And therefore, it was rejected the first time. It went to trial again. On some other technical grounds, it resurfaced, and it was again quashed by the courts. So the thing is that the lessons from these kind of instances from case law is that in order to really protect your own invention, your artistic works, not only must you register, get the patent, pay the appropriate level of fees to register, but you must also collect irrefutable evidence. How would you do that? The irrefutable evidence that it is yours, that you are the owner, would be to get testimonials from companies. Suppose you have developed software and you've given it out on trial, then you get an undertaking from the client that this is yours. You get a declaration that it is on trial, it is under patent, or it is under copyright. You've applied for it, you show them the documentation, you get them to acknowledge it, you get it in writing, so that nobody else can later on claim that it was simultaneously developed by somebody else. Those are all kind of possibilities, and sometimes those possibilities can be very well done. They can be frivolous. Frivolous means mischievous, and somebody can see that your product or service is doing well, and then they can kind of mimic that, and seeing your success, they can file a lawsuit that that property is indeed theirs and not yours. So to kind of dissuade, prevent these things from happening, it is really important to get the patent registered, the trademark registered, pay the fees, collect the irrefutable evidence that it is indeed yours, because you would never know when it would be up to you to prove in a court of law that this product does belong to you, this product or service. Now, there are all kinds of patents. People want to make money and claim that a new formulation, so-called new formulation, may be theirs. For example, recent instances, somebody has claimed a product made out of neem oil, or some of these traditional herbal medicines that unfortunately has been shot down. Not unfortunately, rather fortunately, has been shot down by the courts, because those kind of remedies have existed for hundreds of years and are well known in Ayurveda. So there are protections under the law to really ensure that your artistic work is protected. Now, take coming to academia, in the academic field also, um, protection of publication of writings is in some ways protected, and some ways it is not. Because if you're a scholar, then the responsibility is upon you to make sure that when you are citing, when you are using the works of others, that you are ensuring and giving proper attribution. What attribution means, that if you are referencing some source, it has to be with the proper credit given to those that are the authors of that work. Now, if you try and do any shortcuts and not reference using the proper referencing norms, the consequences can be severe. Today, there are all kinds of plagiarism detection software. And let's say you have a thesis and you have cited, and you have failed to cite, rather, different elements of in your literature review or in other pieces of your thesis. Once it is run through the software and it is detected that a significant portion of your thesis is copied, not given proper attribution, then you can pay the price of that work being rejected. And again, there's no limit to some of this. For example, there have been cases where somebody's work 20 years down the road has been found to be plagiarized, not truly their own work. In that case, a doctorate has been revoked, it has been rescinded. The simple lessons from this is that one has to take proper precautions in registering your work. If you are doing academic work, then proper citations. And unfortunately, there are still cases and instances, but the consequences are severe, and one would rather learn the proper way of doing things rather than making mistakes. So, in terms of intellectual property rights, there are a lot of violations. Some countries they turn a blind eye to all the legal kind of requirements, the recognition, and then that puts your artistic or any other form of work at risk. One of the countries that there's much concern is obviously China, where there's often disregard for intellectual property. And clearly, I don't want to go into the implications, but when that happens, then you can see some countries have built amazing infrastructures, but the intellectual property rights are kind of not all the best, and quite often it is dangerous to trust anybody without the proper registration, without the proper safeguards from a legal standpoint. India and many other countries, including the United States, are very firm on ensuring that intellectual property is protected. And after all, that is justifiably so, because you have spent an enormous number of, amount of time in bringing your inventions or your works of art to the world, and it is only befitting that and justifiable that that is protected. But having said that, the burden is also on the inventor, the trademark holder, to make sure that you comply with all the registration, pay the fees, and are fully aware of the different provisions of the different acts, like the Patents Act of 1970, the Copyright Act, and so on. Now, there are different other forms of violation that one can see in real life. I gave you the example of music, but those infringements extend to all forms in every sphere of life. So again, intellectual property is really the intellect, and that intellectual form of art or product or invention surfaces as something that is concrete and tangible. Now, in terms of the academic side of things, I have kind of outlined some of the challenges. But again, with a more conscious world, the opportunities also are significant. So when one is aware of the laws as well as the loopholes in the law, then there's a better opportunity, there's a better chance for you to take those safeguards that are necessary to protect your intellectual property. Um, in terms of the intellectual property, it's not just lyrics, it can be poetry, it can be, again, software development, it can be industrial secrets, it can be inventions, it can be manufacturing, and the entire spectrum of what exists on human life has a creator. Now, some would be patents would run out, and every patent, every invention has certain time limits. So I've already explained that. But the intellectual property rights are gaining more traction, more recognition in courts of law, as we've seen. The evolution is as things progress. So the electronic media, the act came into being only in the early 2000s or around 2000. Now, for your information, when did intellectual property rights come into being, come into existence? SFS College was born in 1956. Well, 100 years before that, in 1856 was the first time that an engineer in Kolkata or Calcutta by the name of D. Penning invented a device for the panka, the fan, a pulling kind of pulley device to get that in motion. That was the earliest plea that engineer, D. Penning, went to the government and said, this is my invention. I need protection. I need to ensure that I get recognition and revenues. And thereafter, that law was promulgated, and different laws gradually evolved to what we have now. And now with the emergence of technology as something that significantly plays a role in our lives, you can expect more and more patents, more and more protection, more and more filings. During this pandemic, there have been an increase in intellectual property filings because one way to think of that is that people have more time for their productive and creative flair to come come to the fore. So, in terms of intellectual property, the violations can be significant. If somebody borrows, steals an idea from you, and your product or service is a success, then the litigation, the unnecessary kind of getting involved in those kind of battles and disputes will be very protracted because the legal process is rather slow unless it is fast tracked. In the United States, it can be quick, but then the downside is you have to pay intellectual property right lawyers a significant amount of money. So all in all, the lessons from intellectual property is it's an excellent um, kind of protective mechanism to safeguard your intellectual wealth, in your intellectual ideas, your inventions, your creative genius. But in order to do that, also one has to go by the law, abide by it first of all, and if you are not the inventor, then due respect for the law is also important, whether you're an academic or whether you are a student or you are a manufacturer. So I think the world becomes a much better place, and the creativity of everybody is really protected, benefited, and individuals, groups, companies uh, can really then focus their attention on the productive and the creative rather than being drawn into legal battles and fighting for their rights. So it's been a kind of session where I have outlined the different forms of intellectual property, its meaning, its definition, the examples relating to music, to pharmaceuticals, and it's been a pleasure discussing this, and I take this opportunity to thank each and everyone in the audience, distinguished participants, ladies and gentlemen. Thank you very much for the opportunity, and I now turn it back to Kavita and Dr. Dilip Sadankar. Thank you.
I'm audible?
Yes, you are.
Thank you, sir. Thank you, sir. Thank you for your stimulating talk. Your comments were especially helpful to those doing research. We are grateful for the time and effort you took to share your thoughts and experience with us during inaugural speech of today's workshop. You took us to the memory lane of beginning of this concept of IPR. Audience is intrigued by interesting and informative session regarding IPR, not only in India but in the different part of the world, how it works. You have discussed many areas where protection of product or maybe it is an idea, it is useful and significant. You have covered very well all the aspects of protection to ensure to hard-earned intellectual property, maybe by the academician, maybe by the industry person, or maybe a research scholar. Sir, your energy, enthusiasm is contagious, and we hope participants will be benefited from your suggestions. Thank you once again, sir, for your presence. Uh, it was very nice talk. Now I request Kavita ma'am to please take over the session. Over to you, ma'am.
Thank you, sir. Thank you, Dr. Larry D'Souza. May your blessings and guidance always enlighten our path. It gives me immense joy and pleasure to introduce our guest speaker for today's workshop, Dr. Emima Jeronsia. Dr. Emima Jeronsia is Assistant Professor in Holy Cross College, Trichy, Tamil Nadu, offering a wealth of talent in the development and implementation of educational technology, tools, and applications in the classroom. Ma'am is having in-depth knowledge of physics and is adept in creative teaching strategies that fully engage students in the learning process. Dr. Emima Jeronsia is having notable record of publications in international and national academic journals. Her subjects of expertise are nanomaterials for energy applications, thin films, nanomaterials for biomedical applications. Dr. Emima Jeronsia is a member of various intellectual bodies, namely core team member of CPE, that is College with Potential of Excellence, then core team member of FIST, that is Fund for Improvement of S&T, Department of Science and Technology, then innovation ambassador in IPR and technology transfer, innovation coordinator in HCIIC. Ma'am's educational qualifications are BSc in Physics from Holy Cross College, Trichy, MSc in Physics from Loyola College, Chennai, MPhil in Physics from Loyola College, Chennai, and I would like to specify that ma'am was a gold medalist with an huge score of 92% in MPhil Physics. Ma'am has pursued PhD in physics from Loyola College, Chennai. Her title for PhD was Green Synthesis and Characterization of Silver, Zinc Oxide, and Copper Oxide Nanostructures for Potential Biomedical Appliances, an eco-friendly approach. Ma'am has published 15 papers in international publications and has attended and published papers in 10 international and 3 national conferences. Getting aware about ma'am's countless expertise, we are eagerly seeking for the precious knowledge and thoughts Dr. Emima Jeronsia is going to share with us. Over to you, ma'am.
Thank you for a wonderful introduction, ma'am. A very good morning to all the dignitaries, and I really thank the management of St. Francis College for giving me this opportunity to share with you whatever I know about the topic intellectual property rights and how to protect your intellectual property rights. So, can I go about my presentation, ma'am?
Yes, ma'am, sure.
Am I audible? Is my
Yeah,
slides
ma'am.
visible? Okay.
Yes, ma'am. Perfect, ma'am.
So we go on. So the topic is intellectual property rights. What do you mean by, so we'll be going like this. First, we'll be saying what we know, what is actually an intellectual property, then how to protect your intellectual property, and what are the different types of intellectual property rights that we have. Okay. First thing is, I would like to start by asking a question. So this guy's name is Steve, and he's a very big fan of Steve Jobs. So he wanted to start a company, and he wanted to name his company Apple with this logo. So can he do that? Can this guy open a new company in the name Apple, and can he name his? Can he use the same logo? You can put your answers in the chat box. Just say yes or no. No. Thank you, Pravin. Thank you. Thank you. Thank you for your answers, Preeti. Okay, we all know he cannot do that. So this presentation will actually cover why this guy cannot name his company Apple or cannot use the same logo. Why he cannot do that? Because it is protected. How it is protected? That is what we'll be seeing today. Before going into intellectual property, first we have to know what property is. So we can divide property into two types. One is tangible, the other one is intangible. What do you mean by tangible? Tangible property is nothing but you have a car, that is your tangible property. You have a building, you own a building, that is a tangible property. Any movable or immovable things is there, that it's called intangible property. What do you mean by intangible property? Intangible means it is an intellectual property that comes out of your own ideas, your own thinking. When something comes out of that you call that as an intellectual property. So your intellectual properties can be protected. How it can be protected? It can be protected by patents, designs, trademarks, copyrighted. So you can get your intellectual properties can be made into a tangible one, and you can get a patent, design rights or trademarks or copyrighted for your copyright for your own property. So your intellectual property refers to a creation of mind, something that you create, something that you invent, any literary or artistic work, any designs you come up with, any symbols, names, and logos and images used in commerce. Everything that we use is comes under intellectual property. Everything you create, including literary music, all those things comes under intellectual property. And you can protect this intellectual property by law. So by getting a patent, by getting it copyrighted, by getting a trademark for it, by getting an industrial design right for it, all those things will actually is going to give you a recognition that you are the person who is behind this invention. So you will get a financial benefit and also a recognition once you protect your invention. That is the reason why it is very very important to protect your intellectual property. So intellectual property can be divided into many types: patents, trademarks, industrial designs, plant varieties, copyrights, geographical indication, or integrated circuits, any confidential information. All those things comes under intellectual property. But we will be focusing on patent, trademark, copyright, and industrial design in this session. Okay, because those are kind of the four important things that all should know. Okay, what do you mean by patent? A patent as a government authority is giving you a license for something that you invent for a particular period of time. They are giving you a license, or the government authority is giving you a license for your invention. So what that is going to do is it is going to protect you. It is going to give you a sole right over that invention. It will exclude others from making, using, or selling your invention. Okay, so I'll tell you a story. This is a story of Joseph Friedman. He was in a coffee shop with his fruit juice shop with his daughter. So he was buying a juice, and we all know juices are given in a very long glass. Okay, so in the long glass there was a straw. So his daughter was very little. She was struggling to drink through that straw. She was getting up and she was struggling to drink through the straw because the straw is not flexible. So he came up with an idea of making a flexible straw because he saw his daughter struggling to drink a juice. So he thought, okay, why can't I come up with a new idea of making a flexible straw? So he came up with an idea of making a flexible straw, and he has done it, and he got patent for that, for making for the process of making that flexible straw. He got a patent in the year 1937. So he named his company as Flexible Straw Corporation, and he renamed it as Flex Straw Company in 1939. And finally, he sold the right. He sold his patent right to Maryland Cup Corporation, and that Maryland Cup Corporation is producing 500 millions of straws every year. So imagine, it is according to us, it's a very small invention. Without even knowing it, we are using flexible straws. But there is a patent behind it, and one guy is enjoying the rights over it. He is the inventor, and he is enjoying the monetary benefits, and he's recognized as he is the person who is behind the flexible straw, which is actually very very useful nowadays. So that is the reason why getting a patent is very very necessary, to enjoy exclusive right over your invention. And the inventor gets monopoly from the state for a certain period of time. So you will disclose all the full details of your invention to the government, and you will get a monopoly from the state for a certain period of time. So patented inventions, we all know, is in every aspect of human life, from electric bulb to plastics to ballpoint pens to microprocessor patents held by Intel. So patents is kind of everywhere. Every aspect of human life, there was patents in various fields. So patents provide incentives to and protection for individuals by offering them recognition for their creativity and the possibility of material reward for their inventions. So next question comes to our mind. What can be patented? So can I patent anything, any invention? Can I come up with something that is obvious and can I patent it? No. So first we should know what can be patented. So any invention that is very, very novel, that should be unique. So novelty is very, very important. And next thing is non-obvious. See, we all know turmeric has an antibacterial property. It is an obvious thing. We all know that. So if you're coming up with an invention which uses turmeric, and that is kind of an obvious thing. So you will not be able to get a patent for it. So when you file for a patent, you should keep in mind that your product or your invention is non-obvious and it is novel, and which should be capable of industrial application. You should be able to produce in bulk and make it as an industrial application oriented products or invention. And the one more thing that you should consider is it must not be declared non-patentable under Patent Act. So in India, we have Patent Act. In that Patent Act, there are some items which are not patentable to India. So you should go and check there whether your item comes under that non-patentable act. If not, it can be patented. If it comes under that, you cannot patent that invention in India. So like a process of making a chemical compound that can be patented. A machine like a television, a smartphones can be patented. A bicycle, the model of a bicycle, the process of making a bicycle, a table that can be patented. A composition of matter like shampoo, a cleaning solution, if the composition, whatever they are putting it inside, can be patented. And for Pantene, they're using this rice water and they're promoting their product. So, what are the composition of that particular shampoo so that they can get patent for it, so that nobody else can use the same combination and make a shampoo out of it. So, those things can be patented. What cannot be patented in India? A mere idea or a discovery. Discovery means it is already there, you're discovering it. So if it is already there and you're discovering it, that kind of things, it comes under discovery. Okay. What does non-obvious means? I've given an example, right? Neem has antibacterial benefit and turmeric has antibacterial property. These are kind of obvious things, and we all know that, right? So we all know that we all know that that comes under obvious things. So if you are using the same turmeric or neem and making a cream out of it, and say you're going to get a patent for it, that is kind of obvious. We all know that. So no kind of patent will be given to you. Is that clear, Yukta ma'am? So next is contrary to natural laws. According to India, if it is contrary to public morality or natural laws, that cannot be patented. Or mere arrangement or rearrangement of things. Okay, if there is already a cleaner or cleanser that is available. So you're the product is arranged in such a way 1, 2, 3, 4, and you're making it as 3, 4, 5, 1, and you're making a new product out of it. That is nothing a rearrangement of things. Those kind of things cannot be patented. Or as I told you, new use
Hello,
or
madam.
property. Yeah. Yes,
Hello,
sir.
madam.
Yes, sir.
Means what cannot be patented in India? The last part, computer program per se. Means every computer program is new in the beginning for any complex
Yes, sir.
program.
It
So
cannot be
how?
patented. It can be copyrighted. I'll explain, sir.
Oh, copyrighted.
Yes, sir. Yes, sir. It does
Okay.
not come under patent. It comes under copyright.
Okay.
Hello, excuse me. The participant are asked request to ask their questions at the end, not in between. Please.
You can post your queries in the chat box after the presentation. I will answer it. Is that okay?
Yes, ma'am. Go ahead, ma'am, please.
Okay, thank you. So method of agriculture, horticulture, those things cannot be patented in India. And animals, plants and microorganisms, any mathematical or business method or any computer programs cannot be patented in India. Okay. So what are the different types of patent applications that are available? So, okay, you have come up with a beautiful invention that is novel, that is non-obvious, and it is capable of industrial application, that does not come under non-patentable item. Now you want to file for a patent. What are the different types of patent applications you have? One is called provisional, the other one is called non-provisional. What I mean by provisional application is, so you have a very good idea for an invention, and you're halfway through it. You are halfway through inventing that invention. So, but you want to kind of make it safe. You don't want others to copy that or make an invention, make a product out of it. In that case, you can file for a provisional application. Your provisional application is kind of a preliminary or temporary application, which you're applying to protect your invention, because nobody else can do it. So provisional application is also known as temporary application, is filed when an invention is under experimentation. You're doing an experimentation and it is not finalized, but you don't want others to copy it or make an invention out of it. So you can protect it by applying for a provisional application. It is kind of a preliminary application which is filed before the patent office for claiming priority. You're actually claiming priority that I am the one who has come up with this idea. In that application, you will not give any kind of specifications about your product. Okay, so they will give you some time, a year or so. After that, you have to file for an ordinary or non-provisional application. What do you mean by non-provisional application? Is non-provisional ordinary application contains all the information about your product. So this is an example of a razor. Here you can see. So by filing a non-provisional application, all the details about the razor is you should give that all the details necessary, all the how it works, everything you will be providing during this non-provisional or an ordinary application. Okay. The next kind of application is conventional application. What do you mean by conventional application? Is a conventional application is filed for claiming priority date based on the same or substantially similar application field in any of the conventional countries. We say we have conventional countries. So in that conventional country, if I am filing a patent in India and I want to get a patent in another country, patent is territorial. So if once you apply in India, it is not universal. It is actually territorial. So once I file in India, I have to file in whatever country I want my patent. Then you have to file in all those countries for a patent. So your conventional application will do what is, so once you have filed in this one country, so you have to file in another country. So you can say that I have priority over it because I have already filed my parent patent in India or in some other country. So I'm now applying that in your country. So the group of conventional countries are there. So you can quote and file it so that you get the priority in that country also. So that kind of application is called conventional application. Next thing we have is a PCT. That is, PCT is nothing but international application to streamline your patent application process in many countries at a go. So your PCT application is an international application. There is no universal patent available. Patent is territorial. Hence, patent is territorial. The application does not provide a grant for an international patent. But what you can do is, it paves the way for a streamlined patent application process. You can apply for a patent in many countries at one go. It is governed by Patent Corporation Treaty and it can be validated up to 142 countries. So at a time, you can file patent in 142 countries under PCT international application. So filling this application would protect an invention from being replicated in those countries. So in those countries also, they cannot replicate your invention. It is actually you're protecting it. Okay. You have a time frame of 30 to 31 months to enter into various countries for international filing. After filing the parent application, you have 30 to 31 months to enter into various countries and file an international patent. Next comes the PCT national phase. PCT national phase means what is? The application must be filled if the applicant discovers that he has come across an invention. It is considered essential for an applicant to file for a national phase application in each of the country wherein the protection is sought. In whatever country, you can choose the country in which you want protection over your invention. So you can choose it and you can apply for a patent. Here is how it goes actually. First, you file your priority application. Next, you file your PCT application. Then you enter a national stage and you can pick the country that you want. Europe, China, Japan. Here I want to get patent for my invention. So from the priority application, you have 12 months to file for your PCT application. Then you have 30 to 31 months to enter into the national stage of picking up the country that you want and you can file for your patent in those countries. Next application we have is patent of addition. So I already have an invention and I have applied for a patent. Now you are coming up with a new idea of adding something new to your patent, adding something new to your invention. So you can apply for patent of addition. This application discovers that you have come across an invention which is a slight modification of your original invention, which is already applied. So you can file for a patent of addition. So patent of addition is only granted after the patent of parent patent. After you get the parent patent, you get the patent of addition. And as it does not have any kind of separate renewal fee or something, and the date also expires once your parent patent expires. This is called patent of addition. Then you have divisional application. An application, divisional application means what is? So you are coming up with an invention. You have many novelty in that invention. Actually, you are combining 2 or 3 invention and you are putting it as a product. Then you can get patent for each of that invention. So imagine you're coming up with the 3 new products and you're combining 3 new products and making a whole product out of it. So you can get patent for those 3 new products and your whole product. So that for that you have to apply for a divisional application, where divide an application to furnish 2 or more application. When you have more than one invention, you can go for divisional applications. So these are the different types of applications that you can apply for. You have to see under which you want to apply. First, you will be applying for a provisional or a non-provisional application. Then you have to choose whether you want to go for an international one, whether you want to go for a national stage, whether your invention has multiple inventions in it, whether you have to apply for a divisional patent, or whether you are going to add something and you can apply for a patent of addition. So how this process actually goes is, the process to get a patent goes like this. First, you have to apply for a patent application. It is actually available online, or you can get help from the lawyers who are expert in patent. You can get help from them. You can apply for a patent. Then there will be an examination. So after examination, if the examination committee is happy with your invention, if they think that this invention is new, novel, and non-obvious, then they will give you a response. So after getting the response, you will be asked to come and give a presentation where they will be asking you questions. And if they are satisfied with your answers, and if they are satisfied with your product, then the patent will be granted. So after the granting of the patent, the term of patent is 20 years from the filing date of the application. Once you file, from that date onwards, after 20 years, till 20 years, you will have the sole right over your product. So if anybody wants to use your product, then they have to get permission from you to make use of it. So after 20 years, what is going to happen? So after 20 years, the patent expires. So anybody can make use of or sell or make or import the invention without your permission, without the permission of the patent owner, provided it is not subject matter is not covered by unexpired patent. Certain pharmaceutical patents can be extended as provided by law. Our laws give some benefits to pharmaceutical patents so that it can be extended after 20 years also. Okay. So this is another interesting invention or interesting patent. This guy's name is Walter Hunt. And Hunt made an invention in order to pay off a debt of $15 to his friend. He owed his friend $15. He wants to pay back that $15 to his friend. So he used a piece of a brass wire that is about 8 inches long and a coil, and he made a safety pin. It's nothing but he made a safety pin out of it. So after making that safety pin, he applied for a patent and he got in 1849. He got a patent and he sold his patent right to W.R. Grace and Company for $400. That is roughly $12,000 in 2019, but it is very costly now in 2021. But he sold that patent right for just $400. So using that money, he paid his friend $15 and he kept the remaining $385 to himself. What this Walter Hunt actually not realized is, in the years to follow, this W. Grace and Company would make millions of dollars in profit for this invention. We all know how safety pin is very, very important, right? It is a very important invention, and almost in all the places, in all the households, the main thing that we have is safety pin, and it is an essential thing. So this guy didn't realize that his invention is going to be very huge and he will be able to earn a lot by his invention. Without having any kind of future perspective, he sold his invention
to WR Grace and Company, and that company earned a lot using his invention. So when you invent something, when we come up with a very good idea, when we invent something, we have to be very careful. We have to think twice before selling that patent to some other company, because you should keep in mind, you should think very futuristically whether this invention is going to change something. After 20 years, this invention will be a part of every household. You should think way ahead before you think of selling your patent or anything. This is another important patent: lithium ion batteries, a revolutionary battery. We all know everybody is using lithium ion batteries because our mobile phones are lithium ion battery. He is a Japanese scientist, Akira Yoshino, and is the father of lithium ion battery. His inventions now power nearly 5 billion smartphones, as well as it drives electric vehicles. We all know Tesla Motors, Tesla car. He is using lithium ion batteries, electric vehicles, countless other devices. For 30 years, he has been dedicated to continually improving his revolutionary technology. And he is the guy known as the father of lithium ion battery. And he got patent for his lithium ion battery, and his patent numbers are given. So it is very, very important. Once you invent something, getting a patent is very, very important. And he is the one of the youngest patent holder in India. This guy is from Jaipur. He draws his inspiration from scientist Stephen Hawking. He's a wheelchair-bound 9-year-old boy, and he invented a game of six-player chess. So only we know two-player chess game, right? He invented a game of six-player chess, and he got patent for his six-player chess board. Not board, how to make that six-player chess board. Process of making that, he got a patent for it. And his name is Hirdiyashwar Singh Bhati. He's just 9 years old, and he got a game design patent in his name. So he is a kind of an inspiration to all of us, because getting a patent has no age limit. So the next thing that we are going to get into is copyright. So what is copyright? It is the right which grants protection to a unique expression of idea. You're not protecting your idea, you're protecting the way that you're expressing your idea for a limited number of time. How you express your idea? Through literary works, through songs, through music, through movies. You can express your idea, your creativity. So through copyright, you can protect those ideas, those unique expression of ideas. There is no requirement for novelty or uniqueness there, as in patent law. Copyright law protects the expression of the idea, but not the idea itself. So what is the copyright? Copyright allows authors, musicians, artists, etc. to make money of their labor. It prevents others from taking their work for free. It also prevents people from altering the work without their permission. So what can be copyrighted in India? You can get copyright for your music, lyrics, film, video, motion pictures, designs, your softwares. Your software comes under copyright. And painting, fashion designing, that is your textile design, a pictorial representation of something, your website, your blogs, your podcast, your books, journals, and your papers, your articles comes under copyright. So you can protect your unique expression of ideas like music through copyright. Okay. What cannot be copyrighted in India is any ideas, methods, or systems like making a building or a scientific or technical thing, technical methods, a process of making a shampoo. Those kind of things cannot be copyrighted. Then the standard calendars, we all know height, weight chart, standard calendars that is already available, that is kind of standard. So you are just modifying a simple thing that cannot be commonly known information, cannot be copyrighted. Any choreography works cannot be copyrighted until it is transformed into a tangible form. Whether you're choreographing something and you're making it in a video and you're putting it in a CD or an internet platform, if you're doing that, that can be copyrighted. But any choreography work just you're doing on stage, that cannot, somebody is copying that, that cannot be copyrighted. And speeches that have not been transcribed cannot be copyrighted. Any names, titles, short phrases like think different, McDonald's, I'm loving it, those kind of, it's finger licking good for KFC, those kind of catchy slogans, titles of works or business names cannot be copyrighted. It can be trademarked. So I'll tell you what trademark is, but it cannot be copyrighted. The next thing is fashion. You cannot copyright a shirt or a dress, but the design of that particular shirt or a dress can be copyrighted. Okay. So what does this copyright actually give you? It gives you the right to reproduce the work. It gives you the right to prepare derivative of that work, right to distribute copies for sale, and right to perform those songs or those musics publicly, and right to display musical and artistic work like a painting. You have the sole right to display those kind of works publicly since your work is copyrighted. So what do you mean by fair use? The next thing that we have to know in copyright is fair use. What do you mean by fair use is if I want to use that material for criticism. So everybody is now using a clip of a movie for a memes or clip of lyrics for creating for a criticism they are using. So if they are using it like that, it comes under fair use. That is not a copyright violation or copyright infringement, because for the purpose of criticism they are using a part of that particular material for commenting, for news reporting, for teaching. If you're using, I can use n number of quotes from Steve Jobs, from Elon Musk. I can take sources from everywhere. I can use it. A part of the thing I can use it. That comes under fair use because it comes under teaching, scholarship, and research. But I have to give credit for it. At the end, I have to put a reference that I have to take. I have taken all those materials from these different websites. Like that, I have to give credit for it. And limitations apply. That means this include consideration of the purpose. Fair use means why you are using it and for what purpose you're using it. That is actually very, very important when we're using something for a fair use. So what is the alternative to copyright is licensing. So creators can retain the copyright. I can keep my copyright and I can give license to people. So okay, I'm giving you license to use my music or my video for this long of time, for 10 years or so. For you can use, I'm giving you license, so you can use it. For example, the copyright can give schools to use the content for free. See, I am creating a e-content on the topic microprocessor. So what I can do is I can give license to you as a creator. I own the copyright to that particular video. So I can give license to all the educational sectors to make use of my video for their classes. So those kind of thing comes under licensing. What do you mean by open licenses? Open licenses, other can use it, but what they can do, but they have to give credit to you. While writing a paper, we refer from all the many journals, right? While writing a research article, but we always put them in reference. We always give credit to the original source. From there, I have taken this sentence is taken from this particular journal. After that sentence, we put a reference saying that, okay, we are giving credit to that original source. Okay, that is another thing that we should do. So plagiarism, license is permission granted by the copyright holder. I am giving you license to copy, distribute, display, transfer, or perform any copyrighted work. Plagiarism means passing off another author's work or ideas as one's own. I am not giving any kind of credit to them. I'm not even giving them as their reference, but I'm using their sentence in my journal or in my research article. That comes under plagiarism. And public domain. Works that are not restricted by copyright and do not require a license or free to use. That is actually public domain. Works can enter the public domain automatically, like internet. If your work enters the internet, it comes under public domain and it automatically becomes they are not copyrightable because it is released in a public domain. The next thing we have to know is copyright infringement. Copyright infringement refers to the unauthorized use of someone's copyrighted work. So you are using an unauthorizedly, you are using someone else's work. That comes under copyright infringement. That thus it is the use of someone's copyrighted work without their permission, thereby you're violating their rights. That is copyright holders' right you're violating. So such as the right to reproduce, distribute, display, or perform the protected work. This is an interesting case. I'll give you two case studies. One is Sanjeev Pillai and Tiruchirappalli. This is the case between these two guys. Sanjeev Pillai is a director of a movie. So while directing that movie, he came up with a beautiful script. He is actually the script writer. He came up with a beautiful script after researching all the traditional background of a particular community. He researched all those things and he came up with a beautiful script and he started directing that movie. He went to Venukurapalli, he is the producer, and he gave permission to this director Sanjeev Pillai to direct that movie. So while directing, what happens is some clash is happening between the Sanjeev Pillai and Venu Kunapalli, and there is a misunderstanding. And Venu Kunapalli asks Sanjeev Pillai to leave the movie in between. So I don't want you to be the director of this movie. I will have some other new director and I'll direct the movie. He said, and this Sanjeev Pillai left the movie in between. So this Venu Kunapalli, he called some other new director and he changed a few aspects of the script. He changed it and he started directing the remaining movie. So before releasing that movie, what happened is this Sanjeev Pillai filed a case against Venu Kunapalli saying that that is my script. I have done a lot of research for this script. So this is actually, I have the sole right over it. So he cannot release this movie without giving credits to me because it is my work. So he cannot release this movie without giving credits to me. So what happens in the court? The court rules in the favor of Sanjeev Pillai because he is the script writer. So the whatever he writes, it comes under his copyrighted item. So without giving any kind of credit to Sanjeev Pillai, if you release this movie, this movie is kind of banned. So after only this case is solved and enough credit is given to Sanjeev Pillai, this movie came into existence or came into theaters. The next beautiful thing is the University of Oxford versus Rameshwari photocopy services. There is this photocopy service in the University of Oxford in New Delhi. So what happens is this Rameshwari photocopy services, they started taking photocopies of the books that the university is using, the book materials that the university is using for the purpose of students. What they started photocopying, giving photocopies of that particular book to students. They started distributing the photocopy of that particular book to the students. So what this University of Oxford, the Vice Chancellor and all the important faculties of universities, they filed a case against this Rameshwari photocopy services. What do you think? Who actually wins this case? Can you guess whether University of Oxford or Rameshwari photocopy services? Which you think won this case? University or photocopy? Rameshwari. Very good, ma'am. Kamal Jyoti. Rameshwari. Can you tell the reason why Rameshwari won? Cost is less. Very good, ma'am. But the actual reason is this Rameshwari photocopy is in that university building itself. It is a licensed photocopy shop in the university, in the north wing of the university. So the university has given license to this photocopy shop to operate. So once the license is given, they have the license, so they can photocopy anything they want. And also it is for the purpose of academics. So when it comes to academics, and also the license is given by the university to this Rameshwari photocopy services, so they can give any photocopies of any material because they have license and it is for the purpose of academics. So Rameshwari photocopy services actually won the case. So this is the importance of having a copyright, and also we should know how to make use of that copyright and the nooks and corners. Once you have a license, what are the rights you have as a holding a license? What are the rights you have? That you should know. Actually, this Rameshwari photocopy won because they have the license and the purpose is for academic purposes. So duration and term of copyright. So in the case of original literary, dramatic, musical, and artistic work, the duration of copyright is the lifetime of the author or artist and 60 years counted from the year of following the death of the author. So lifetime of the author, after the death of the author, it is extended up to 60 years for literary, dramatic, musical, and artistic work. In the case of cinematographic films, sound recordings, photographs, publications, works of government or international organization are protected for a period of 60 years, which is counted from the year following the date of publication. The next topic is, before going into the topic, I would like to ask few questions. You can see different logos here. Can you tell what is the first logo? That is 4 ring represents which company or which brand? You can put your answers in the chat box. First 4 rings represents Audi. Very good, very good. Simon, Pramod, Yukta, Preeti ma'am, Ankita, very good ma'am, very good. It represents Audi. The second one, M, I'm loving it. Second one, M, I'm loving it. McDonald's, very good. And the third one, which is represented here, the third one, it is a car company. Suzuki, Maruti Suzuki, very good. And the fourth one, a tick mark, Nike. Wonderful, wonderful. So we are able to find the company or the brand. We are able to identify the company or the brand just by seeing their logo. So that is why a logo is very, very important. We are able to differentiate between a Benz and a BMW just by seeing their logo. A BMW and an Audi just by seeing their logo. That is why a logo or a logo is very, very important. So that important thing should be protected. And how you can protect it? You can protect it by getting a trademark registered for it. So you can see first one is Audi, McDonald's, Maruti Suzuki, and Nike. So we all know Yahoo, Adidas, Burger King, Walmart, Google, everything. Just by seeing their logo, we'll be able to identify and relate to this is this brand, this is this brand, and they produce car and they produce computer chips. Like that, we are able to differentiate and identify those brands just by seeing their logos. So protecting that logos is very, very important. There comes the trademark. A symbol, a logo, a word, a sound, a color, a design, or other devices that is used to identify a business or a product in commerce that can be trademarked. A trademark owner can be an individual or a business organization. A trademark should be located on a package, a label, or a product itself. The trademark will be located so that we'll be easily identifying that this belongs to this. So things that can be trademarked. What are the things that can be trademarked? Word marks like Google, sound marks, devices and symbols, any shape or a 3D marks, color marks can be trademarked. These things can be trademarked. The color combination of Coca-Cola is trademarked. Nobody can use it. The colors of Google, the word marks of Google is trademarked. So nobody else can use those same word marks combination for their products. So what cannot be trademarked in India? In India, without a distinct nature, like an apple, if it doesn't have a common name without any kind of a distinctive nature, that cannot be trademarked in India. Any name or surname, like Pradeepa M. Singh versus Singh Associates, both have same names. Any name or surname cannot be trademarked in India. And any color, like Cadbury's purple color, those kind of colors, color because of color deprivation, those kind of colors cannot be trademarked in India. A particular color cannot be trademarked in India. Or geographical location. So imagine I'm coming with a new product. I want to name it Tamil Nadu. So those kind of names cannot be trademarked since it is a geographical location. And number that does not possess any distinct character. A number without any value like random 1, 2, 3 or like that, if you are going to give some numbers in your logos, that cannot, numbers as your slogan or a logo, that cannot be trademarked. And sound, factual distinctiveness means that sound marks can be trademarked. What I mean by sound is the sound of a barking dog. Like in the Tom and Jerry, when we were kids, in Tom and Jerry, we used to, at the beginning of Tom and Jerry, there will be a lion roaring sound. So those kind of sounds can be trademarked in their country, but in India, those kind of sounds cannot be trademarked. Like a dog barking, like a lion roaring, those kind of sounds cannot be trademarked. But musical, like a sound note, sound marks can be trademarked. Okay. And anything that comes with anything with the smell that not easily distinguishable and are subjective to nature. Smell is subjective to nature. So something that comes up with an aroma or a smell that cannot be trademarked in India. So these are the different types of trademarks. Here you can see the shape of the bottle is trademarked. And the name of the bottle, that is Coca-Cola, is trademarked. And the symbol M is trademarked by McDonald's. And this slogan, I'm loving it, is also trademarked by McDonald's. And this color orange is trademarked by this company. And the Volkswagen, the logo type of Volkswagen is trademarked. So you can trademark these many things. In a logo, you may have a slogan, you may have a shape, you may have a symbol. You have to get trademark for each and every of those things. Okay. So how to go about this process is, first thing that you have to do it, you have to search for a logo. You are coming up with a new logo for your company. So you have to check whether somebody else is using that logo in India or not. For that, you have to do a logo search. After doing that, now nobody is using that logo. Then you can apply for a trademark. That comes the application form. Then you will get an application number. That application will be examined. And after the examination, you will be getting a response. And your logo, once they are very satisfied that your logo is something new and unique, so nobody else has used your kind of logo, then they will advertise your logo or your slogan or your color combination in an advertise in a trademark journal. So after advertising, you will get a certificate of registration. Once you get the certificate of registration, that logo or that symbol completely belongs to you and your company. So if somebody else is using that, you can file a case against them. Then also you can renew your trademark periodically after 10 years. It has the validity of 10 years. After 10 years, you can keep on renewing your trademark. The term of registration for trademark is 10 years, which may be renewed for further period of 10 years. So what happens is, once you apply for a trademark, you can put a symbol of TM in your logo or in your product. You can put a symbol of TM. That means that you have applied for a trademark. So you should not use it that I have applied for a trademark. Don't use it. You're kind of giving a warning. Then once you have registered the trademark, you can put a symbol of R with a circle saying that this trademark belongs to this company. So you don't have any rights. Others don't have any rights over this logo or over this design or over this color combination. So you can get it registered. After getting registered, you put a symbol R with a circle. So what happens if somebody tries to infringe your trademark? So direct infringement is there. Somebody without getting any authorization, unauthorized person is using your same kind of logo or some identical one. See, somebody will be using. In India, we can see many identical things. Like Adidas will be there. The logo will be reversed and the spelling will be there. Adidas. I will not be there. So we will not be able to, by suddenly seeing, we will not be able to differentiate whether it is an original Adidas or a duplicate one, because they will be using kind of a same logo with the spelling mistakes will be there. So those kind of things we should be able to see through it, whether okay, someone is making a fake one, someone is making an identical one with very small change. So those kind of infringement are taking place. And registered trademarks, they are using the registered trademarks and class of goods or services. What do you mean by indirect infringement is, so somebody that is your relative or somebody in your company is using a logo that is already registered, that is already used by some other company. So you know that, but you're not taking any kind of action, you're not suggesting or anything. That actually comes under indirect infringement. See, imagine I am running a company. An employee is working under me. I am asking my employee to come up with a logo. So that employee is coming up with the logo without cross-checking anything. I'm just okay. Apply for a trademark. Okay, we use it on our products. And if I give them permission, that I am making a indirect infringement. So what I should do, I should check whether some other company is using the same color combination, using the same style or using the same logo. I should cross check. If I didn't cross check and I'm using that product, that comes under indirect infringement. Here you can see examples. Here you can see Adidas, Adidas. There is only a spelling change will be there, but the symbol, everything, color change will be there, but everything else will remain the same. So the user will not be able to differentiate immediately between the original product and the duplicate product. So what kind of legal action should I take in the case of trademark infringement? You can definitely file a case in the court. In Delhi, Mumbai, Calcutta, and Chennai, you can find, these are the four high courts where you can go and file somebody else. If somebody else misuses your trademark. So after filing that, they will stop that party, the party that those who are using your trademark, they will stop them, and they will ask them to pay your damages and costs. They will have to pay you for the damages, and they have to surrender all their infringed goods. Whatever goods they are manufactured so far, they have surrendered it to the court. Surrender all the bills, letterheads, transparencies, pamphlets, and brochures with the same trademarks. If they have prepared all those things, then they have to surrender all those things to the court of law so that they cannot use it further. So this actually will also give you a cost. They will also provide you a cost or a damage cost. They will provide you for using your trademark without your knowledge. The next interesting thing is industrial design. What do you mean by industrial design? Before going into that, I would like to ask you a question. Which bottle you prefer? This bottle is A bottle and this one is B. If you're going to a shop, will you buy an A bottle or a B bottle? Just type A or B. A. Others, I would like B. Very good. A, B, B, B. So the majority of the answer is B. So the next question is, these are two different types of backpacks. When you're going to a shop and you have the choice between this buying this A bag or B bag, which one will you choose? B. A. B. B. Okay, the most of the answer is B. So next, coming into chair. Which chair would you prefer? A1 or B1? B. B. Very good. Thank you so much. So the majority of the answer is B, and the reason is what? Majority of us have answered B. The reason is the design. The purpose of the chair is the same. The purpose of the bag is also the same. The purpose of the water bottle is also the same. Of course, we see the quality, but the main thing that attracts us is the design. Because we always get attracted towards something that looks nice, something that looks beautiful, something that has a beautiful design. Because we are human beings, we are naturally attracted to those things. So that is the reason why majority of us chose B, because of the appearance. So appearance is very, very important. Very good, Ankita ma'am. Appearance is very, very important. Appearance is nothing but design. Industrial design. We call that as a industrial design. Industrial design is nothing but relates to the appearance of an article, how a product looks. Because nowadays people are buying some. When we go to shop, we all, even the purpose of the water bottle is the same. We buy something. We are ready to pay extra 100 rupees for a beautiful looking water bottle because we are very much drawn to the appearance. So appearance, industrial design relates to this appearance of an article, how the product looks and what the design is. It doesn't actually protect the technical or the functional features of that product. It only protects the industrial design. It only protects the design of that particular product or any handicrafts. Okay. It can be any two-dimensional figures such as lion, colors, patterns. It can be a three-dimensional figure such as shape of an article. It can be 2D or 3D like this. Any two-dimensional pattern or any three-dimensional like toys that we make for kids, and any car, three-dimensional model of a car, three-dimensional model of a mobile phone. All these things, you can get an industrial design rights for it. So why you need an industrial design right? In order to get an industrial design, you should see to that it should be novel, that it must be original. Okay, must be new, must be original. Should not disclose anywhere to the public in India. In India or any other countries by publication. Like people should not use it like it should not be already disclosed to the public. Okay, it should be kept as a secret, and after only getting the industrial design, you have to give it to the public. So it should not be given to the public in prior. And also, it should significantly differs from the known design or the combination of the known design features. It should actually differ from the original design or the known design that is well known. Okay, it should differ. The design should completely be different and should not be conflicting with public order or morals or integrity, moral values or integrity. If it should not be conflicting to that, and it should not, of course, prejudicial to the security of India. So these things that we have to keep in mind. See, for example, not by change in shape, change in size. If you change the size of a design, industrial design, if you change the size of a product, that does not comes under industrial design. If you change the shape, then it is considered. Like here you can see, here is a normal idli, here is a mini idli. Here you can see, here is a square idli. Square idli is actually a change in shape. I'm giving you an example as idli, but if there is a change in shape, then it is considered as an industrial design. You can apply for an industrial design. But if it is only changing in size, then it will not come under industrial design. Like designs of stamps, labels, token, cards that cannot be registered for industrial design. Articles like any cartoons that will not come under industrial designs. So how long this protection of design is there is duration of the protection is for 10 to 25 years, and you can extend it up to another 5 years of the term. You can extend it. So when an industrial design is protected by registration, the owner is granted the right to prevent unauthorized copying or imitation by the third parties. So you can completely protect your design. So here you can say Coca-Cola bottle. The design of this Coca-Cola bottle is actually registered. So nobody else in the world can use this Coca-Cola bottle design without the permission of the company. Okay, here is the model of this car. Is a Mini Cooper car. The model of the Mini Cooper car is actually comes under registered industrial design. So if BMW company wants to make a car like this, then they have to get permission and from the Mini Cooper company to produce such a model, same model kind of car, same design. They have to get a permission. That is why it is very, very important to get registered for your industrial design also. Next is the interesting topic. We all know that is geographical indication. So geographical indication, it is an indication. It originates from a particular geographical territory like Banarasi sari, Kanchipuram pattu, Malkova mango. All these things represents a geographical indication. So who can apply for this geographical indication? Till now, whether it will come under one single person or it will come under a company. But when it comes to geographical indication, there will be an association of person or a producer or an organization established authority by the law. So they will be applying for the geographical indication. So how long this registration of geographical indication is valid is for 10 years, and it can be renewed after the period of 10 years. These are some of the famous geographical indication patent granted by Indian Patent Office in the year 2017-18. Tirupati Laddu, Darjeeling tea, Kangra paintings, Nagpur orange, Kashmir Pashmina, Panganapalli mangoes. So these are famous geographical indication granted by Indian Patent Office in the year 2017 to 2018. And with this talk will be over. So what are trade secrets? This actually we have to know what a trade secret is. A trade secret is a formula or a practice or a process or a design or anything that you don't want to disclose it to anyone. I want to keep it as a secret. I don't want it to get disclosed to anyone, because when you apply for a patent, you will be disclosing everything about the process. When you apply for a copyright, when you have a copyright, you are actually disclosing everything. When you are applying for industrial design, then you are disclosing all the design, all the specifications of your design. But if somebody doesn't want to do that, then they can keep it as a secret, and that secrets are called trade secrets or confidential information or classified information. One of the two famous companies that are keeping their information confidential is Coca-Cola and KFC. So if you want to work in Coca-Cola or KFC, then you have to sign a non-disclosure agreement saying that the recipes of that Coca-Cola, the recipes of the KFC, you will not reveal anything. So you have to sign that non-disclosure agreement so that nobody knows what actually is the recipe of KFC, what actually is the mixture of Coca-Cola, because they are keeping it as a trade secret. Because if they apply patent for it, after 20 years the patent expires. Anyway, it will go to the public knowledge. So they don't want their company's recipes to go into public even after 20 years. So they are keeping it as a trade secret. But when you keep it as a trade secret and once it is released in a public domain, you have no protection over it. You cannot even file a lawsuit because You don't have patent over it because you're keeping it as a trade secret. So this picture will give you a complete understanding of IP. Coca-Cola is the best company you can see for IP related things. So this is Coca-Cola's bottle. So here you can see the logo and the script of the Coca-Cola, and the logo is copyrighted. Next, the logo, script design, and the shape of the distinct shape of the Coke bottle is trademarked. And the methods of making that plastic container, barrier coated plastic container, comes under patent. And the formula for making the Coca-Cola is kept as a trade secret. And the design of this Coca-Cola bottle is registered and lapsed in the year 1940. So just one bottle of Coca-Cola is having so much IP protected over it. They have copyright, they have trademark, they have patent, they are keeping it as a trade secret, they have the design registration. That is why it is very, very, very important to know what is patent, what is copyright, to know your right, actually, to know your intellectual property right and how important it is. Actually, compared to European, American, and Japan or China, India is a little bit lagging in the understanding of patents and the importance of applying for patent, copyright, and trademarks. So it is the high time that because we people are very creative, we people are very intellectual, so we can come up with the new inventions, but we should know how to protect that invention. Hope this session is useful for you. If you have any kind of, this is where I took the information from official website of Intellectual Property of India, www.ipindia.nic.in, iprlawindia.org. You can go here. If you have any kind of queries, you can post it there, and they will answer you. If not, this is my mail ID, jeroemialex@gmail.com. You can contact me anytime. And if you are coming up with a new invention and you want me to help with the patent process or the copyright process, we have actually few lawyers with us. So we will connect you to that lawyer so you can get help from that lawyer, because law point of view we have to see, because this will give you an idea of what patent is, what copyright is, and everything. So when you want to apply for it, we will be needing a help of a lawyer. So we have one or two lawyers with us. Those who they will be willing. They are based on Chennai, but they will be willing you to help when you come up with a new invention or when you have any doubts related to copyright or anything. So every new idea looks crazy at first. So never stop thinking, improving, and innovating. With this, I would like to wind up. Thank you very much for being such a wonderful participants, for being such an interactive participant. I don't know how this 1 hour went. It was such a wonderful time. Thank you very much. Thank you one and all, and I thank the management for giving me this opportunity.
Thank you, ma'am. Though your talk was extremely crisp and clear, we have received some questions from our participants.
Sure,
Ma'am, can you proceed with the question answer session?
Yes, ma'am. Sure, ma'am.
Okay. So, ma'am, first question is, what is your advice if I want to get IPR as soon as possible without any issues?
If you want to get it without any issues, better apply for a provisional application. That means if you are not coming up with a complete idea of your invention, you have not come up with a full experimentation of your invention, that you can apply for provisional application. Provisional application, there you will not need to provide all the information about your invention. It is just keeping your idea safe. Okay, my idea or my invention will be safe. So they will give you a period of 6 months or 1 year. So after that, you have to submit a complete application with all the specifications of your invention. So if you want to protect it, but if you are not ready with your whole invention, then you can apply for a provisional application. That is my advice.
Okay, thank you, ma'am. Ma'am, one more question.
Yeah.
What is claim priority?
Claim priority means you have applied. See, I'm coming up with a new invention. So I have applied that patent for that invention in India. So I want to get patent in some other countries too, because patent is territorial. So what I can do is I have already applied in India. So I will tell the date in which I have applied in India, and I will apply there in that country also. At that time, I will get a priority since I have come up with a new invention and I have applied already in my own country, my parent country. That is called client priority. So I can say that you give priority to me because I come up with this invention and I have applied patent in my country. So that is what you call claiming the priority since you have applied it already.
Okay, ma'am. Thank you so much. Ma'am, there is a request. Can you please turn your camera on if at all you are comfortable?
It is on
Um, okay, but ma'am, we cannot see you.
from other device actually.
Yes, yes.
Can you see
Okay,
me? Yeah.
okay, ma'am. Ma'am, one more question we are having.
Yeah,
Uh,
sure.
can the patent application be filed electronically in India?
Online, it is available. You can file it online. It is there in the website. With the help of a lawyer, you can file it online. It is actually easy. You can file it by yourself. But while filing, we will have many doubts and we will be needing some clarification or advice from a lawyer. So you can find a law firm, those who are expert in applying for a patent. You can get a help from them. You can file it online. It is now online. You can do it online.
Okay, ma'am. So that is it with question and answer session. And other questions we will forward to ma'am. And
Sure, ma'am.
okay, okay, ma'am. So thank you, ma'am. Your talk was extremely grateful and encouraging. The knowledge you shared regarding intellectual property rights will definitely help us in future. And I'm sure that the knowledge we have gained today will definitely help in economic growth and competitiveness and to generate breakthrough solutions to global challenges. And will also encourage innovation and reward entrepreneurs. I'm feeling extremely grateful to thank everyone who made efforts to make this program a grand success. First and foremost, I thank our chief guest, Dr. Lionel D'Souza, for his gracious presence and valuable guidance. Thank you, sir, for sharing your precious time with us. Then I would like to thank our beloved principal, Dr. K.T. Thomas, for always being supportive and motivating to conduct such programs. Thank you, sir, for your valuable guidance. Then I would like to thank the organizing team who made this possible to execute this program very smoothly and effectively. Dr. Dilip Sadankar, Ms. Neha Shinde, Ms. Rashmi Pandey, Ms. Reshma Kazi, Ms. Surbi Valde, and Ms. Pinky Gidwani. Without their sincere efforts and technical support, this program would not have been possible. I also thank Sorry. I also thank all the participants. Without their active participation, this program could not even be imagined to take place. In my final words, I thank everyone for their kind attention and patience. I request all the participants to stand in honor of our national anthem. Thank you.
पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उज्जल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगल नायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
Thomas sir,